let's begin. Senator Seitz, traditionally, in order for someone to be criminally prosecuted and to go to jail, the government had to show that a person not only did the bad act, but had a guilty mind or criminal intent. If they didn't have both of those, they didn't deserve to go to jail. Not that what they did wasn't wrong, but they didn't deserve to go to jail. But does that traditional legal protection still exist in our criminal laws? And if not, what did Ohio do to fix the problem?
Well, thank you very much. It's a pleasure to be with you. A little shout out to my colleague, Senator Edna Brown from Ohio, and my former colleague, Representative Ted Celeste from Ohio. But I'm delighted to be here in Orlando. The answer to your question directly is that to a large extent those traditional protections have eroded because we are now applying the criminal law in many, many circumstances that traditionally were addressed only in the civil law. Generally speaking, negligent actions and actions for which there was strict liability were only able to be remediated in the civil courts, but increasingly we are applying criminal sanctions to people who merely acted carelessly or to people who had no guilty mind at all. That is a signal problem, and that is the problem that we addressed in Ohio 2 years ago with the unanimously passed mens rea bill that we were successful in enacting. So I'm here today to talk about the 7 deadly sins. No, not the ones that are enshrined in our religious tradition, rather the 7 deadly sins of overcriminalization. And for all the reasons that Representative Hurley mentioned, this is something we need to address. And like North Carolina, we have addressed all 7 of those 7 deadly sins in Ohio. The first deadly sin is the one I'll spend most of my time on. Poorly drafted criminal laws that fail to clearly describe what level of guilty intent the offender must have in order to violate the law. This failure leaves it up to courts to interpret what we failed to tell them what to do. When this happens, people may be convicted without intending or even knowing that they were breaking the law. Classic example. Many of our states have enhanced penalties for people who knowingly assault someone that we want to protect, be it a police officer, fireman, police dog, service dog, you name it, nurse, healthcare worker, judge. When the statute merely says it is enhanced penalty to knowingly assault such a person, the word knowingly only modifies the word assault. So if you knew that you were assaulting someone but did not know or have reason to know that they were a police officer, fireman, etc., you would be guilty of the enhanced penalty. That doesn't make sense. So after 14 years of trying to correct my colleagues on every occasion in which they failed to specify the proper degree of mens rea for these kinds of penalties, I came up with an idea, and we enacted it. The first part of the bill says any new criminal offense that fails to appropriately specify the degree of guilty mind required for conviction is void and unenforceable. The second part of the bill says any existing offense or any amendment to an existing offense that fails to adequately specify the degree of mens rea as to each element of the crime for which guilty knowledge may fairly be inferred can only be a secure conviction upon a proof that the defendant acted recklessly, which means with heedless indifference to the consequences of his or her action. I had wanted to say knowingly, but these things are a matter of compromise. My friends at the Manhattan Institute, Buckeye Institute, Texas Public Policy Foundation worked with me on the bill, but prosecutors will oppose bills like this because they want it to be very easy to convict the proverbial ham sandwich. And they do not like to have enhanced standards for what level of guilty mind is required. We were ultimately able to settle on this recklessly default standard, and coupled with the prohibition on enforceability of new criminal offenses that do not involve an adequate degree of guilty mind specified in the bill, I think will be a very good deterrent. In fact, in the 2 years since we passed it, I've noticed an increased attentiveness on the part of my colleagues when they propose new bills to actually do the work and specify the degree of guilty mind that is required. The second deadly sin is sentence enhancement bills, such as mandatory maximums or increasing the length of sentences in ways that make no sense. If an 11-year mandatory maximum sentence is not enough to deter a drug dealer, what makes us think that doubling it would do a better job of deterring a drug dealer? If we have increased sentences on some sex offenses to the point where the offender would face an equal or lesser sentence by killing the victim, what have we solved? Have we paid attention to the legislation that is increasing sentences just so we can pose for the cameras or act like we have solved a problem presented by a particularly bad case that might originate in our district? Inadequately thought through sentencing enhancement laws are the second deadly sin of overcriminalization. The third deadly sin is to fail to put resources behind evidence-based programs in prison education and job training and similar programs in community corrections and probation. Over 95% of prison inmates will get out someday. If we do not offer meaningful job training and educational opportunities to them while they're in prison and incentivize them to participate in those programs by offering modest earned credit off their sentence if they do, what makes us think they will be anything other than better criminals when they get out? There is abundant evidence that these efforts reduce recidivism, and by the way, in Ohio, we have the lowest recidivism rate in the country at only 28%, when the national average is hovering between 40 and 50%. We've done those things in Ohio. The fourth deadly sin is to erect a wall of collateral sanctions that accompany a criminal conviction. For example, in Ohio, we just repealed a law that required driver license suspensions for all drug offenders, even for conduct wholly unrelated to driving. In Ohio, judges now have discretion whether to suspend the driver's license or not. If you can't drive, you can't work, and you're more likely to drive under suspension, and if you get caught, have your probation revoked and get sent back to prison. There are hundreds of similar collateral sanctions, barriers to state licensure, even as a hairdresser, if you have ever been convicted of any criminal offense. That makes no sense. Limits on when long ago convictions can be sealed or expunged from the record. Laws allowing plaintiff lawyers to sue employers for negligently hiring an ex-con, a principal reason why employers don't hire ex-cons. We changed that in Ohio by giving employers immunity if they hire someone that we have certified to be rehabilitated. The list goes on. A system that does not reduce the barriers to employment of rehabilitated ex-offenders is the hallmark of the fourth deadly sin of overcriminalization. The fifth deadly sin is to fail to reform a criminal justice system whose pretrial procedures are inadequate to prevent a wrongful conviction of the innocent defendant. You are committing the fifth deadly sin if you do not work to allow the defense to have meaningful pretrial discovery of the prosecution's evidence. If you don't have strong laws requiring the retention of the evidence. If you don't mandate or at least incentivize the use of videotaped or audiotaped confessions so that we can determine whether they're genuine or coerced. Or when your state allows a tainted procedure for lineups and police photo arrays to allow police to improperly influence the identification of whodunit. The sixth deadly sin is to allow onerous restrictions on post-conviction relief proceedings. We now have a new law in Ohio that gives defendants in post-conviction relief cases the same rights as they have in federal court to seek discovery on whether the prosecution failed to turn over all the evidence they were supposed to, or other kinds of flaws in the trial proceedings. We have laws that give all defendants the rights to get a DNA test at the state expense so that they can prove that biological evidence establishes their actual innocence. Finally, the last thing I'll mention, the seventh deadly sin, and this is the one area in Ohio where I wish we had done more, is to countenance unduly restrictive parole consideration. Surely crime victims and their families have a right to be heard at parole board hearings. Nobody disputes that. But in many cases, parole boards routinely deny parole eligibility to model prisoners who by any measure are rehabilitated, and all risk assessment instruments show that they are at little risk of reoffending or endangering community safety. Why? Because the parole board entries all too often state the nature of the offense that the inmate committed. We're not going to grant parole, and they get flopped. Frankly, nothing the inmate could do could change the nature of the offense for which they were sentenced. And legislation to require that parole be denied only if there are articulable reasons beyond nature of the offense beyond community opposition. If we could do that, that would be a good idea. What we have done in Ohio is put term limits on the parole board members so they don't deny parole just to preserve their own jobs. And we are also considering legislation that we hope to pass by the end of the year that would give offenders sentenced as juveniles to life without parole the opportunity for a parole eligibility hearing after 20 years. These, ladies and gentlemen, are the 7 deadly sins of overcriminalization. Action may be taken to combat each of the 7 deadly sins, but it starts with a meaningful definition of what actually constitutes a guilty mind in order to warrant the excessive cost of imprisoning these folks. And I would urge you to consider the Ohio model of a mens rea bill in order to take the first step at combating the first of the 7 deadly sins. Thank you.